Good afternoon, everyone. For those who have joined us early, thank you for waiting patiently. While we wait for our session to begin, we would like to share a short video about our firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the Legal Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us today for today's online talk entitled Born Here, But Don't Belong, Latest Malaysian Citizenship Cases and Their Impact on Stateless Individuals. My name is Clarissa, a pupil in Chambers at Mount Kwan Associates, and I will be your moderator for today's session. Before we begin, allow me to briefly introduce our firm and the work that we do. Mount Kwan Associates is a mid-sized law firm founded in 1985 by Datuk Mount Kwan. Our able team today consists of 30 lawyers and a support team of 32. Following his retirement from the Court of Appeal bench in 2015, Datuk Ma now serves as a consultant with the firm. Firm continues its tradition today, working primarily with SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department including litigation, adjudication, and arbitration, a dedicated employment/industrial relations team, and a department focused on serving the needs of individuals and families. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is about our MWKA online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which we have been broadcasted live, but the COVID-19 MCO, we have since transitioned online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice. Should you require any specific legal advice in relation to your matter, please contact us for a complimentary legal consultation. Further details will be provided at the end of this talk. We have two speakers for today. Allow me to introduce our first speaker. Ms. Kritika is an associate at Mount Kwan Associates. She was admitted to the Malaysian bar in January 2023. Kritika graduated from the University of Leeds in 2020 and subsequently completed her bar professional training course in 2021. Her areas of practice include family and citizenship matters, employment law, strata management disputes, and criminal defense. Our second speaker, Alyssa, is also an associate at Mount Kwan Associates. She graduated from the International Islamic University, Malaysia in 2022 and was admitted to the Malaysian bar in October 2023. Her areas of practice include general and commercial litigation and family law, specifically adoption, citizenship applications, and divorce proceedings. In today's talk, Ms. Kritika and Alyssa will enlighten us on the latest Malaysian citizenship cases and their impact on stateless individuals, including research cases in the Federal Court of Appeal and High Court, judgments that redefine citizenship entitlements, evidence needed to prove abandonment, and lastly, legal strategies following rejection of citizenship applications. With that, I will now hand over the session to Ms. Alyssa.
Hi, good afternoon, everyone. My name is Alisa, and thank you, Clarissa, for the introduction. So today I will be talking about the first two top points in today's talk, recent cases in the Federal Court of Appeal and High Court, as well as judgments that have redefined citizenship entitlements. But before I begin, I would like to just introduce briefly on essentially what is the law regarding Malaysian citizenship in Malaysia. Malaysian citizenship in Malaysia, there are multiple ways in order to acquire citizenship in Malaysia. Firstly, we have citizenship by operation of law, pursuant to Article 14 of the Federal Constitution, which is mainly what we will be discussing today. We also have citizenship by registration, which is governed from Articles 15 to 18 of the Federal Constitution. We have citizenship by naturalization, as well as citizenship by incorporation of territory. So briefly, or as an overview, in terms of the recognition of citizenship by operation of law under Article 14(1)(b) of the Federal Constitution, it's governed from sections 1A until 1E of Part 2 of the second schedule. So the first categorization or the first classification that we must look at in order to determine which of these provisions are applicable, we need to look at where the child was born. If the child was born within the Federation, sections 1A and or 1E would apply. So for section 1A, if one of the person or one of the child's parents is a Malaysian or a permanent resident at the time of the person's birth. Secondly, 1E, the child or the person must not be born a citizen of any other country. So this section would be read together with section 2, subsection 3, which is that a person must be treated as having at birth any citizenship which he acquires within 1 year afterwards. So these are the provisions that will be applicable if the child or the person was born within the Federation. If the child was born outside of the Federation, then other provisions would apply, such as sections 1B and 1C, in which the child will be entitled to citizenship by operation of law by virtue of the child's father, who at the time of the child's birth is a citizen and was born in the Federation, or the child whose father is at the time of the birth a citizen and whose birth is registered within 1 year. There's also section 1D, which is specific for children or people born in Singapore, of whose parents one at least is at the time of the birth a citizen and who is not born a citizen. So these are essentially the general provisions that are used when it comes to citizenship by operation of law pursuant to Article 14(1)(b) of the Federal Constitution. So with that, we move on to recent cases that have been decided by all levels of court, which have progressed or which have shown us what are the legal trends currently in court regarding citizenship applications. So the first one that we would like to talk about is very recent. This is actually one of our clients, FDN and NDN. So they are siblings. The plaintiffs were born in 1994, 1995 in Kuala Lumpur to FADN, their father, who is a Malaysian, and M, their mother, who was an Indonesian citizen. So the parents registered their marriage in 2007 after the children were born, and their father passed away thereafter. In 2022, they applied to legitimize themselves, and the Shah Alam High Court declared that the plaintiffs are the legitimate children of FADN and M. However, they were not considered as citizens due to them being illegitimate or born out of wedlock. So in 2023, they filed an originating summons to seek reliefs, which included a declaration that they were citizens of Malaysia by way of the two provisions that were mentioned earlier, by virtue of their births within the Federation, pursuant to Section 1E, Article 14(1)(b), and as well as Section 1E, as well as by virtue of the citizenship status of their father, FADN, pursuant to Article 14(1)(b) and Part 2, Section A. So we finally got the decision for this last month in December 2025, where the High Court of Kuala Lumpur allowed the plaintiff's application and declared them as citizens of Malaysia pursuant to Article 14(1)(b) and Part 2, Section 1A. So by virtue of the citizenship status of their father, FADN. So this was in the High Court of Kuala Lumpur. The second case that is also quite recent it was in 2024. So this plaintiff, Shamiti Yusof, she was born in 2001 to Wan and Yusuf bin Mahmud, her parents. And similarly to the previous case, the parents were not married at the time of her birth. And then sometime in 2004, the mother left the plaintiff, leaving her father to raise her until his passing in 2018. So her birth was registered under a late birth registration 6 years after her birth. So because of that, the JPN proceeded to issue a late birth registration. And in her first birth certificate, it was stated that she was a citizen. So she was a warga negara on her first birth. But when she later went to JPN to apply for her IC, she discovered that a second birth certificate had been issued without her knowledge. And in that second birth certificate, her citizenship status was changed from warga negara to bukan warga negara. Because of that, she filed an originating summons in the High Court, if not mistaken. And so the authorities here claim that this amendment was made under Section 30 of the Registration of Births and Deaths Ordinance. And even though she never applied to change her citizenship, and she only approached JPN at that time for the purpose of obtaining an IC. The issues at the time before the court were basically two. One, whether the defendants here were empowered to amend her birth certificate and subsequently, because of that amendment, revoke her citizenship. And secondly, whether she's entitled to citizenship by virtue of Section 1A as well as Section 1E. So the findings of the court with regards to the amendment of a birth certificate, the High Court there held that JPN and the Registrar of Births and Deaths do not have the power to revoke citizenship by simply amending a birth certificate, because citizenship can only be deprived under Articles 24 to 27 of the Federal Constitution, which require notice, due process, and a proper inquiry. So in this case, she was never given notice, she was never informed of any deprivation proceedings, and no inquiry under Article 27 was conducted. So the change from citizen to non-citizen in her birth certificates were therefore a unilateral act, and it was done without legal authority. So as a result, the court there found that the second birth certificate was unconstitutional, null and void, because it effectively deprived her of her citizenship without following the procedure or the guidelines set out in the Constitution. So the judge also emphasized that administrative laws on birth registration cannot override constitutional protections. With regards to the findings of the court on her citizenship by operation of law, so the judge explained that Malaysia's constitution applies both jus soli, or citizenship by way of birth, and jus sanguinis, which is citizenship by parentage, and that these provisions must be interpreted broadly, especially where a child risks becoming stateless. Here, the court said that citizenship is not merely an administrative status, it's a fundamental constitutional right. And any interpretation that leads to statelessness must therefore be approached with extreme caution. So the court found that she satisfied Section 1E because, one, she was born in Malaysia after Malaysia Day, and second, she was not born a citizen of any other country, nor did she have any other foreign citizenship within 1 year of her birth. So pursuant to the 1E that we mentioned earlier. And also, one thing to highlight is that in this case, the government failed to produce any evidence that she was a citizen of another country. So merely questioning the status of her biological mother was not enough. And the judge held that if she was denied Malaysian citizenship, she would become stateless because she did not have any other foreign citizenship. And this is contrary to the purpose and spirit of the Constitution. So because of that, the court declared her as a Malaysian citizen by operation of law and ordered the reinstatement of her original birth certificate. So this argument or strategy that we're seeing is quite recent, I would say. And there is another case following these along these same grounds, I would say, in Peninsular Malaysia, in the case of Leong Wei Kit. So this was in 2025 in the High Court of Malacca. The plaintiffs were legally married in 1992 and they were childless for many years. The child was born in Klang in 2009. So here, the child's birth was registered in 2009 at Metro Medical Center, Klang, and the birth certificate stated that the plaintiffs were the parents of the child. But then when the child reached 12, the plaintiffs brought him to JPN to apply for his IC, but the officer there noted that the facial features of the plaintiffs were different from that of the child. So there was an investigation that was conducted in respect of the background of the child. So during this investigation, the parents were asked to apply to amend the child's birth certificate under Section 27(3) of the Registration of Birth and Death Act 1957. So in this, the parents also signed statutory declaration stating that they were not the biological parents. So consequently, the original birth certificate was seized and there was a second birth certificate that was issued. And in that second birth certificate, the parents' particulars were replaced with maklumat tidak diperolehi, and his citizenship status was changed from warga negara to bukan warga negara, which was similar to Siti Aisyah just now. After that, the plaintiffs decided to legally adopt the child, and then they got an adoption order from the High Court of Malacca. But the citizenship status of the child remained as bukan warga negara on the birth certificate, which meant that the child was stateless. So because they were dissatisfied, they filed an originating summons and submitted that the child is a Malaysian citizen by operation of law under Article 14(1)(b) and Section 1E. Similarly to Siti Aisyah just now, the findings of the court can be split into two, basically, one on the amendment of the birth certificate, secondly on the citizenship. So the High Court of Malacca, with regards to the amendment of the birth certificate, stated that Section 27(3) only allows for the correction of clerical or factual errors, so not drastic changes that would affect parentage as well as citizenship status. And the court found that the parents did not genuinely require the amendments, and their intention was only to obtain a my card, not to revoke citizenship. The court also stressed that the parents were ordinary citizens, they had no legal advice, they only followed JPN's instructions, believing that it would help their child. And the statutory declarations that they signed and affirmed was also not properly explained and did not meet the legal standard required under Section 27(3). With regards to the findings of the court for the child citizenship, the court again said, similar to Siti Aisyah, that the provisions must be interpreted broadly. And it was found that the child was born in Malaysia after Malaysia Day and was initially registered as a citizen. So if he was already registered as a citizen of Malaysia from birth, it would be legally impossible for this child to have acquired another citizenship within 1 year of his birth. That would mean that the child would fulfill Section 1E. And removing the citizenship of this child would render the child stateless, and it would go against the purpose and spirit of the Constitution. In addition to that, the parents also made positive assertions that the child was not a citizen of any other country, the child never acquired foreign citizenship, and these assertions were not able to be contradicted by the defendants. They did not provide any credible evidence to say that the child acquired other foreign citizenship, and the court held that the plaintiff's evidence then stands unrebutted, and the burden shifts to the defendants to prove otherwise, to prove that the child does have a foreign citizenship. In the end, the court held that the amendment of the birth certificate was unlawful and that the child is a Malaysian citizen by operation of law, and thus the application was accordingly allowed. So this and Siti Aisyah were two similar cases, which wasn't just a discussion on citizenship by operation of law, but it was also a discussion on amendments of birth certificate and whether JPN has the power to amend birth certificate and thus revoke citizenship based on these amendments. Moving on to a higher court, so we have Court of Appeal cases. One that's quite, I would say, recent and also very important to look at is the case of TSY. This was also handled by our firm. So the appellant was born in 1983 in Johor. The appellant did not know the identity of her biological parents, nor did she have any information about them. So when she was still an infant, she was sold by her biological mother to a woman who later registered her birth in early 1984. She grew up in difficult circumstances, and despite this, she never held a Malaysian birth certificate stating her citizenship, and her parentage remains officially unknown. As an adult, she was issued a My Caste identity card, so it identified her as a non-citizen, and she kept renewing this card over the years with the authorities, and she was not given any clear pathway to regularize her status as a citizen, even though she was born and raised entirely in Malaysia. When she attempted to apply for citizenship, she was informed that she could not apply because her birth certificate does not contain the details of her biological parents. She was advised to pursue naturalization, but it required her to first obtain permanent residence, which is not possible because she does not have foreign citizenship and is not able to apply for permanent residence. And the immigration department even refused to allow her to apply for an entry permit or a permanent residency because she doesn't have a passport, she doesn't have a nationality, she doesn't have any parental information. So because of that, she was stuck in essentially what is a legal dead end. She's unable to apply for anything or to have any meaningful legal status. So because of that, she sought a court declaration that she is a Malaysian citizenship by operation of law because she was born here in Malaysia. In April 2019, she applied to the High Court for a declaration that she's a Malaysian pursuant to Section 1E on the basis that she was born here in Malaysia and was not a citizen of any other country. So in 2020, the High Court dismissed her originating summons. So she then appealed, bringing the matter before the Court of Appeal. In the Court of Appeal, the central issue here was whether paragraph 1E operates as a standalone provision or whether it must be read together with 1E. So what this means is that whether it requires her to prove her biological parentage in order to determine her citizenship status. So the appellant here argued that she had already established a case. She was born within the Federation and she did not acquire any other citizenship within 1 year of her birth. So she relied on 1E. So on this basis, she contended that the burden now shifts to the government or the state to prove otherwise. However, the Court of Appeal agreed with the respondent or the government or JPN and held that 1E is not a standalone provision, and it requires both jus soli, so place of birth, as well as lineage. According to the court, Section 2.3 does not dispense with the need to prove lineage, but it's a temporal deeming provision, meaning that any citizenship acquired within 1 year after birth as having been acquired at the time of birth. So this does not remove the requirement to first determine whether such foreign citizenship could have arisen through the parents. The court expressly aligned this approach with the majority decision in CTEB, which we will discuss later, which is that the point here is that the relevant point in time to determine citizenship is at birth, and that paragraph 1E must be interpreted consistently with this framework. So on the issue of burden of proof, the Court of Appeal held that here the burden lies squarely on her to prove that she was not born a citizen of any other country. And the court stated that statelessness is a positive fact, it must be established by evidence. And the court acknowledged that even though 1E is actually intended to prevent statelessness, the court distinguished this with federal court's decision in CCH, which we will also discuss later. So in CCH, it involved an abandoned child, but here she was not legally characterized as abandoned. So therefore, the court declined to apply a broader reasoning to the appellant's case. So ultimately, the Court of Appeal concluded that because the identity and nationality of the appellant's biological parents were unknown, it was impossible to determine whether she had acquired foreign citizenship at birth, and therefore she failed to satisfy paragraph 1E, and the appeal was dismissed. The appellant obtained leave to appeal again to the federal court against the decision in 2023, and the hearing before the federal court was fixed in early January 2025. But prior to the hearing, she was informed that GPN had allowed her application for citizenship pursuant to Article 19, which was naturalization. And because of that, she consequently withdrew her appeal. And she's now happily a Malaysian citizen. Another very interesting case that happened in the Court of Appeal here is the government of Malaysia against WKH. WKH was born to a Kenyan father and a mother whose identity was merely known as Lilis Benny at Hospital Keningau in Sabah in 1995. So his father passed away when he was 10 and his mother passed away when he was 17. He made his application for citizenship in 2007 under Article 15A, but he didn't receive any answer. He made a second application about 7 years later, but was ultimately rejected. So because of that, he filed a judicial review application against the decision of the government that dismissed his application. The High Court of KL allowed the application, finding that his birth certificate is considered as prima facie evidence that he was born to a Malaysian father, and that the entry on the birth certificate amounts to conclusive evidence. And so now that he has proven that, and the burden shifts to the state to prove otherwise, the court found that he had discharged his burden of proof in showing that he was not a citizen of any other country because he wrote to the Indonesian embassy. So because of that, in 2019, the government actually filed an appeal against the decision of the High Court, and the Court of Appeal actually affirmed the High Court's decision that the respondent, WKH, was a Malaysian citizen by operation of law by virtue of his birth in Malaysia pursuant to Section 1E. But the Court of Appeal held that basically the Court of Appeal reiterated the points of the High Court, that the details on the respondent's birth certificate are conclusive and that he had already discharged his burden of proof in showing that he is not a citizen of any other country when the respondent wrote to the Indonesian embassy to obtain confirmation of his status as an Indonesian citizen. So because of that, the government, along with other applicants, applied for leave to appeal to the federal court against this decision in 2022. However, the federal court unanimously dismissed the government's leave application with no order as to cause. So the Court of Appeal judgment still remains good law and it has not been overturned as of now. So now that we've talked about recent cases or what the courts are deciding recently, let's look at judgments that have redefined citizenship entitlements. So if you are familiar with citizenship applications, you will know that there are one or two landmark decisions by the higher courts that basically change the game, I would say, or redefine citizenship entitlements. So the first one that I would like to talk about is CTEB. So in CTEB, the appellant here was born in the Philippines in 2010 to a Malaysian father and a Filipino mother out of wedlock. And the parents only registered their marriage 5 months later. So the appellant here has a Philippines passport. In 2011, he applied to the first and third respondents for citizenship under Article 15A, and that was rejected. In 2016, the first and second appellants, the second appellant here is his father, filed an originating summons for a declaration that he is a citizen by operation of law under Article 14(1)(b), or alternatively a citizen under Article 15(2). In the High Court, actually, the learned judge held that because he was an illegitimate child, he was not allowed to take up the citizenship of his father, the second appellant. So this limits his lineage to his mother. And since she is not a Malaysian, the first appellant is therefore not entitled to citizenship by operation of law under Section 1B. And even though he was considered as legitimated upon his parents' marriage subsequent to his birth, it was considered as immaterial to the construction of the provisions of the federal court. Because of that, he appealed. And on appeal, the Court of Appeal agreed with the reasoning of the High Court and affirmed, basically based on the same judicial decisions relied on by the High Court, that because he's an illegitimate child, he was not allowed to take up the citizenship of his father, and therefore he is limited to the lineage of his mother. So because of that, the appellants filed a motion for leave to appeal to the federal court, which was allowed on the following questions of law. So basically the questions of law are whether the words born outside the federation in Part 2, Section 1B can be properly read as requiring the child not hold any other citizenship and or passport or be stateless in order to qualify for Malaysian citizenship by operation of law, and whether the fact that the biological parents of the child who were not married to each other at the time of the child's birth but subsequently marry disqualifies the child from acquiring a Malaysian citizenship by operation of law pursuant to Article 14(1)(b) and Section 1B of the second schedule. So those are, among others, the main questions of law that were posed to the federal court. But unfortunately, the federal court dismissed the appeal on a 4-3 majority ruling. So the minority judgments, which means that the judges that were for the appellants in the minority, were given by the former Chief Justice Tengku Maimun Tengku Mat, Federal Court Judge Yang Arif Nalini Padmanathan, and Federal Court Judge Yang Arif Mary Lim. In terms of the majority judgment, which means the decision of the court that dismissed the appeal, when it came to discussing on who are parents, the word parents in Section 1A, the court basically held that there is an express distinction for parents or father of an illegitimate child in Section 17. It's obvious that the word parents here must be construed to refer to lawful parents in a marriage in the federation. So this means that parents will always refer to legally wedded parents, not biological father and mother. And then because of that, the federal court referred to Section 17 and basically stating that for the purposes of citizenship, any references to an illegitimate person's father or parent will be construed as references to his mother. So because he is illegitimate, even though his father is Malaysian, any references to the word father will be construed as references to mother. So the federal court stated that even though he was legitimized, so things such as a Legitimacy Act or Adoption Act, they cannot be used to construe the qualification of that person because citizenship should be determined at birth. So subsequent marriage of parents would not change the birth status of the child as an illegitimate child. And there is no corresponding provision in the federal constitution that would deem legitimization as a way to confer the right to citizenship. So that's the majority judgment which caused the dismissal of the appeal. But when we go to the minority judgments or judges that they were in the minority but they were for the appeal, Tengku Maimun, the former Chief Justice, she said that the word father in Section 1B of Part 2 and anywhere else ought to be construed as meaning the biological father. The legitimacy status of any person claiming citizenship is irrelevant in cases where paternity is known and the biological father is a citizen of Malaysia. Previously, the majority judgment would say because he's illegitimate, that he should not follow his father's citizenship, even if his father is a Malaysian. But the minority judgment here given by the former Chief Justice stated that if the paternity is known and the said biological father is a citizen of Malaysia, then the word father here should be construed as meaning biological father. I'm also said that father means biological father, whether a person is illegitimate or not is irrelevant in the determination of their entitlement to citizenship, provided that the identity of their biological father is known. Another federal court judge, Yang Arif Nalini, she, in agreement with the former Chief Justice, she stated that it shouldn't be that you deprive the child of a Malaysian father's citizenship on the grounds that there wasn't a legally recognized marriage. And she said that should only arise when there is no Malaysian father at all. So it does not follow that the citizenship of a legitimate biological father of the child can be ignored just because at the time of the child's birth, the father and mother were not married. Another federal court judge, Arif Mary Lim, also stated that just because the first appellant's father was not married to his mother at the time of his birth in the Philippines does not diminish his right to acquire citizenship by operation of law. The second appellant remains the father, and the legal relationship between the father and mother that should not or does not alter the status of the first appellant. So why are these minority judgments important even though the appellants technically lost the appeal? It's because these two majority and minority decisions, they are competing approaches to the interpretation of these citizenship provisions. So you can see previously that the majority judgment adopted quite a strict technical interpretation, which requires applicants to positively prove lineage and also foreign citizenship status. Meanwhile, the minority judgment viewed citizenship as a fundamental constitutional right. So what was said in the grounds of judgment also, when interpreting other provisions in the federal court, the courts must do so in light of the humanizing and all-pervading provisions of Article 8 of the Federal Constitution. The minority judgments in CTAB emphasize that the citizenship provisions were deliberately drafted to prevent statelessness. Therefore, they must be interpreted broadly and purposively rather than restrictively. And what's more important is that the minority recognized the possibility of proving negative facts. So proving that a child did not acquire foreign citizenship, especially when the child has unknown or undocumented parentage, the requiring of such proof imposes an unrealistic and unfair burden on vulnerable individuals. So CTAB is important in that sense. And what comes after CTAB is also another landmark decision by the federal court and also by the former Chief Justice of Malaysia. The case is CCH. Briefly, CCH involved the baby boy that was abandoned at birth at Hospital University Kebangsaan Malaysia in Cheras, when the identity and nationality of his biological parents were completely unknown. The child was cared for and later formally adopted by the appellants pursuant to a High Court adoption order. However, as we all know, despite the adoption, the registrar issued a new birth certificate classifying the child as a non-citizen, effectively rendering him stateless as he was not a citizen of any other country. Because of that, the appellants filed a judicial review in the High Court to challenge the decision of GPN to issue a birth certificate stating that the child is not a citizen of Malaysia. However, unfortunately, the application was dismissed in the High Court and also the Court of Appeal upon appeal. However, in 2021, the Federal Court held that the child is entitled to citizenship by operation of law by virtue of Section 1A, read with Section 19B, Second Schedule FC. 19B involves abandoned children. My other speaker, Kritika, will also touch on this in a bit. But however, what's important here to note is that some important points that were held by the Federal Court, which going back to our main thing, which is we're looking at judgments that redefine citizenship entitlements. Some important points here is that the Federal Court held that a child is considered to have been found exposed if the child was abandoned at the place of birth by the birth mother whose identity is unknown. According to this, the Federal Court held that if a new child is found exposed or abandoned, then two things are presumed. One, that the child is born to a mother who is permanently resident at the place where the finding was made. And secondly, that the date of the finding is taken as the date of the birth. So the burden of showing that the child's mother was not permanently resident now rests on the respondent or the government. So what does this mean and why is it important? So the Federal Court here showed that once abandonment is shown, then the burden now shifts to the state to rebut this presumption. And it's illogical to require adoptive parents to prove a negative fact. So how do you prove that you don't have something such as foreign citizenship? That's why the burden now shifts to the state to prove that the child does not have foreign citizenship, especially when the state has more superior investigative resources. So that's basically what the Federal Court stated. So you can see here, this case should be important as to how to deal with future cases within the context of abandoned children. The burden is on the respondent to undertake proper investigations. The respondent is obligated by the highest law of the land to recognize that newborn child citizenship by operation of law. And the court also held that the ministry has all the important machinery of the state at their disposal to conduct appropriate investigations to ascertain the truth. So the fact that they couldn't produce any evidence which showed that the child has any other foreign citizenship or any evidence of the biological lineage of the child indicates that they did not discharge their legal burden to rebut this presumption of permanent residence of the child's mother in Section 19B. So that's how important CCH was in terms of the progress or the decision or the court standing when it comes to abandoned children and the use of Section 19B. Another case that I would say would redefine judgments that redefine citizenship entitlements. So this one, most of you might have heard of it. This is the government of Malaysia and others against Suryani Kempe and others. Suryani Kempe was the first respondent here. She was the president of a non-profit society, essentially referred to as Family Frontiers. And the second and seventh respondents in this case were Malaysian mothers who were married to foreign spouses and who have given birth to children overseas or outside of Malaysia. Like I mentioned earlier, Section 1B of the second schedule, the wording is such that it says whose father is at the time of the birth a citizen and born in the Federation. So their application or sought a declaration that this should be interpreted to include mother as well. Because if we look at it, it just means that if your father was a citizen, then Section 1B would apply to you. But what if your mother was a citizen who married a non-Malaysian? How would that work? When the respondents filed this, the High Court had allowed this and basically made an order that said, among others, that this interpretation of the word father should include mother. However, the government of Malaysia filed an appeal against this decision. And in the Court of Appeal, basically, it concerned the issue of gender discrimination, which arose in the context of the inability of a Malaysian mother who is married to a foreigner or a non-Malaysian citizen to pass on her citizenship status to a child who is born outside of Malaysia. So the Court of Appeal was asked to decide whether this section must be interpreted literally or harmoniously following the 2001 constitutional amendment that prohibited gender discrimination. However, on the 5th of August 2022, the Court of Appeal reversed the decision of the High Court by a 2-1 majority. So that means they did not interpret that section to include the word mother. This case was also heard the same as MSAM against this case was actually handled by our firm as well. It was heard together. The decision was also given together. And in MSAM, it involved a child who was born overseas to a Malaysian mother and foreign father, similar, and she was denied citizenship by operation of law and was told to apply under Article 15 instead. And as mentioned, the Court of Appeal reversed the decision of the High Court together with the previous Family Frontiers case. The majority finding in this case was that the children were not entitled to citizenship because their fathers were not Malaysian. Reading the section very straightforwardly, the fathers were not Malaysian. So the court also held that it was bound by the majority decision in CTB, which remains the prevailing law. So the majority held that the word father here refers only to the biological father and cannot be read to include mother or either parent. So the only situation, like in CTB, the only situation where father can be construed as mother is if the child is illegitimate. So the majority rejected the argument that Article 8.2 overrides citizenship provisions. It held that the 2001 amendment inserting gender was not intended to affect other articles, and citizenship provisions are of equal constitutional standing. There's no hierarchy. And even though the court acknowledged that there were real hardships faced by mothers and children, the court held that those grievances must be resolved by parliament, not the judiciary. So these two cases were then, they applied for leave to the federal court. And in December 22, the federal court granted the leave to appeal. Among the questions of law were whether a person born outside the federation to a Malaysian mother is a citizen pursuant to Section 1B, and whether the term father should be ceased to be read literally in a discriminatory way, and whether Article 8.2 of the Federal Constitution should be interpreted to prohibit gender discrimination in matters concerning citizenship. So the hearing was fixed on the 10th of December 2024. However, MSAM was granted citizenship under Article 19 by way of naturalization 1 day before the hearing. However, granting of citizenship under Article 19 did not mean that her children were automatically granted Malaysian citizenship because it only applied to her. And the children to the 6 mothers in the Family Frontiers case were also granted citizenship under Article 15.2. So therefore, because of that, the hearing was adjourned for parties to discuss an amicable settlement. And of course, we know that in October 2024, the Parliament actually passed the Constitution Amendment Bill with a 2/3 majority revising this citizenship provision so that children born overseas to Malaysian mothers are now eligible for automatic citizenship on the same basis as those born to Malaysian fathers. So that's why these cases were very important, because it represented a major policy shift towards gender equality and substantive citizenship rights. So after that, in March 2025, the Family Frontiers and the 6 Malaysian mothers reached landmark settlement with the Malaysian government, which would allow children born abroad to Malaysian mothers to be able to apply for citizenship. So that's all from me. I now pass the floor to the next speaker, Kritika.
Thanks, Clarissa. As addressed previously by Clarissa, I'll be talking about the last 2 points for today, which is the evidence needed to prove abandonment, as well as the legal strategies following rejection of citizenship application. So when we talk about abandonment, what exactly are we referring to in the context of citizenship? So in the context of citizenship, abandonment here applies to Section 19B, Part 3 of the second schedule of the Federal Constitution. In particular, that for the Section 19 provides that for the purposes of Part 1 or Part 2 of this schedule, any newborn child found exposed in any place shall be presumed until the contrary is shown to have been born there of a mother permanently resident there. So this provision is read together with Article 14 as well as Section 1A. So why it's read together is because Section 19 says that the child's mother is then presumed to have been permanently resident there, which means Section 1A will then kick in that because the child's mother is presumed to be a permanent resident, the child is then a citizen of Malaysia. So this principle was actually clearly explained in the case of CCH. I won't go into the details of the facts of the case of CCH because I believe Anisha has already done that at great length. But what I will do is explain the definition of the word found or the phrase found exposed. So this is what the federal court had to say with regards to the term found exposed. They said that this term should include newborn children left abandoned near dump sites, baby hatches or pub or school toilets, places of worship, and so on. And a literal meaning of exposed suggests a newborn child was discovered exposed at any of these locations. So we can see here from this extract of the judgment in CCH that the federal court gave a very broad definition as to the meaning found exposed so as to not limit the potentials of abandonment because technically a baby can be abandoned anywhere. And the operative word here is the word exposed in Section 19B. So it should encompass the plight of newborn children. Otherwise, the overarching intent behind this provision would then be defeated or rendered illusory. So the focus here was to provide as broad as the definition possible to ensure maximum possible protection to babies who are abandoned at birth. So the first case that we were looking at today in terms of the definition or evidence required to prove abandonment is the case of DDL. In the case of DDL, the child here was born to a Sri Lankan woman who was the biological mother in a hospital, and 8 months later, the child was then given up for adoption to the plaintiffs. Upon registration of the child's birth, the child was registered as bukan warga negara or non-citizen, and the plaintiffs made formal applications in court to adopt the child. So when the case was filed at the High Court, the plaintiffs alleged that the child was abandoned because they had no documents to conclusively prove the identity of the child's biological mother. However, in this case, the court dismissed the application on the basis that the facts showed that after the child was born, the child remained with the child's biological mother until the plaintiffs met with her 8 months later. And there was information that was known about her, including her identity and nationality. So that defeated the presumption under Section 90B because here the identity of the child's biological mother was known. And therefore, the abandonment provision, so to speak, didn't kick in. Similarly, in the case of HSM, what had happened here was an absence of a positive assertion that the child was actually a newborn child that was found exposed. Even though there was legal submissions on this point, there was no positive fact that was pleaded that alleged that the child was born abandoned. And what actually happened was that there was no clear narration of what happened after the child was born. After the child was born, there was no explanation of how she ended up in Miri subsequently. So this was a case that was filed and the child was born in Sanakan and then subsequently she suddenly ended up in Miri. So there was no clear chain of custody in terms of the abandonment and there was no explanation in terms of what happened to the child after she was born. So because of that, the court held that it would be very difficult to find that the child was actually abandoned, because there was a break in the chain of narration in this case. And because of that, there was no clear evidence to document the abandonment in that sense. In the case of LSS, what had happened was that there was a statutory declaration that was previously affirmed by the plaintiffs. And in that statutory declaration, applicants had actually said that the child was given to them by the child's biological parents. So then the argument of abandonment, which came in later, was then defeated because of this statutory declaration, because it contradicted the applicant's allegations that the child was actually abandoned at birth. Now, this is a case YYM, which was handled by our firm. And in this case, the child was actually found to have been abandonment and fell within the definition under or within the provision of Section 19B. And the court essentially held that because there was a clear narrative in this case that the child was born in Damai Service Hospital HQ and that the child was then handed to the plaintiff by the plaintiff's acquaintance when the child was a week old, and that all the birth documents supported the fact that the child was actually born in Damai Service Hospital, and that the identity of the child's biological parents could not be discerned from base of the documents available from plaintiffs, that the court held that the child was abandoned and did fall within the definition of Section 19B, that is, a child was found exposed. And in particular, the court held that because there was already this base information of the child being born in Damai Service Hospital, the defendants, in this case, the government of the National Registration Department and Ministry of Home Affairs, ought to have undertaken efforts to have done further investigations into the child's birthplace, that is Damai Service Center. There was a doctor who had essentially signed off on the child's birth records, and no follow-up investigation was conducted, and no investigation was conducted or interviews conducted with respect to the doctor. And so the court found that there was no evidence led by the defendants to prove that the child was actually born outside the Federation or that the child's biological parents were not permanently resident there. So in this case, you can see, in contrast to the earlier cases of DDL, HSM, and LSS, the finding of the court was very different because there was a clear chain of narration. There was evidence tendered by the plaintiffs or the applicants, and there were no further investigations that were undertaken by the defendants to defeat the applicant's allegation that the child was abandoned. So in short, what we can see from these cases is, and obviously this is not necessarily an exhaustive list, this is just a list that we've gleaned based off these reported cases. In order to prove abandonment, you need to essentially ensure these four things. Firstly, that the identity of the biological parents are not known at all. So in the first case of DDL, the identity of the child's biological mother was known, and she was a Sri Lankan. So if the child's biological parent's identity was known, that would be the first failure. You won't be able to prove abandonment on that basis. Secondly, you must clearly plead abandonment or having been found exposed in court papers. Essentially, there must be a clear basis for you to plead abandonment, and you must clearly prove it and remain consistent throughout the proceedings. So you cannot have known the child's biological parents and then subsequently plead that the child was found abandoned. And in relation to that, there cannot have been a break in the chain of custody of the child. So it must be very clearly established what happened after the child was born and then how the child ended up in the custody of the child's adoptive parents. There cannot be a break in between that, because if there is such a break, then the question is then, was the child really abandoned? What happened in between? What part of the story is missing here? And also, obviously, that there must be some evidence of the abandonment, and there cannot be contradicting evidence to that effect. So in terms of the evidence of abandonment, oftentimes what is useful is, if there is a child that is abandoned, obviously from the get-go, the best situation would be for you to lodge a police report. If there is such a police report that is lodged, then this would lend very strong evidence support that the child is abandoned. And this is useful, especially when the child is not abandoned in a hospital or a medical center where there are records of birth. For example, you have babies abandoned in playgrounds, babies abandoned in temples, places of worship, so on and so forth. Then a lodging of a police report would be very useful. And then obviously when the children are born in hospitals, then the birth records to prove that the child was actually born there and then subsequently handed over to the prospective adoptive parents. I'll now move on to my next top point, which is legal strategies following the rejection of citizenship applications. So when we talk about rejection of citizenship applications, what we are referring to is citizenship by way of registration. And by this, we are referring to two articles, namely Article 15.2 as well as Article 15A. So pursuant to Article 15.2, federal government may cause any person under the age of 21 whose parents want at least a citizen to be registered as a citizen. Under Article 15A, the same provisions would apply, but the federal government may do so in special circumstances. So the difference between the two applications between Article 14 and Article 15A 2 is Article 14 applies automatically. So you are deemed a citizen from your date of birth, whereas Article 15 or 15.2, it's not an automatic right. It's by way of application to JPN and KDN. And you are deemed a citizen from the date of granting of your citizenship. Similarly, with Article 14, the birth certificate will record you as having been a citizen, whereas with Article 15A and 52, that is not the case. What will happen is you will get a separate certificate of citizenship. With Article 14, you don't really have an age limit, whereas with Article 15A and 52, only those under the age of 21 are eligible to apply. So the application process is relatively straightforward. So the parents of the applicant or guardian must apply. They must have some sort of familial tie or have been granted custody of the child. One of the parents has to be a citizen. We note that Article 15A doesn't really require one of the parents or the guardians to be a citizen. Practically speaking, both the same forms are used for Article 15 and Article 15A applications. And what this means is then there is a requirement for one of the parents to have been a citizen, at least practically speaking, when you submit the application at the National Registration Department. So the application is by way of filling up a form, you pay the fee. If the citizenship is granted, then ringgit fee is payable for the issuance of the certificate of citizenship. Now, the downside with Article 15A and 52 application is that if the application is rejected, there is no reasoning that is provided by the government. There is no exact timeline for the processing of the applications. So in the past, we've seen applications take anywhere between a few months to 5 to 6 years. So it really depends on each individual application. And effective mid-2026, with the change in the amendments to the citizenship provisions of the federal constitution, there will be a reduction in the eligibility rate age. So from 21, it will apply to only those under 18. And of course, the last disadvantage is that you can't repeatedly put in applications. You can only put in an application once you've gotten a rejection from the previous application that you've put in. What happens once you receive a rejection for your 15A application? The best strategy would be to file a new application, obviously, if you're still eligible to do so. That means if the child involved is still under the age of 18, you would put in a new application as soon as possible. If you fall within the criteria on the slide, so that means if you're born in Malaysia to a Malaysian father and a non-Malaysian mother out of wedlock, if you were born overseas to a Malaysian mother and a non-Malaysian father before the citizenship amendments come into force, or if you were born overseas to a Malaysian father out of wedlock, or if you were born in Malaysia and the identity of your biological parents is not known, you could then potentially also consider filing an application in court, like we've seen in all the previous cases that we've discussed earlier today. Of course, with the last category, I put here subject to requirements. And what I mean by this is, if you're born in Malaysia and the identity of your biological parents are not known, you need to have some sort of a person with a familial tie to you who is a Malaysian citizen. So oftentimes this comes in the form of adoptive parents who would then put in the application on behalf of the child who's abandoned. So there still needs to be some tie to Malaysia in terms of putting in the application, as well as having some sort of basis for you to file an application in court. So when I say here subject to requirements, this is what I mean. Subject to the requirements being granted, being true for the 15A application. So the benefit with filing these applications in court is that just because you file an application in court, that doesn't disqualify you from being entitled to file the application under Article 15A or 52 and vice versa. So they are two completely separate provisions, and one doesn't disentitle you to the other in that sense. So that brings us to the end of our talk for today. We'll now proceed to the question portion of today's.
Thank you, Kirtika and Alyssa, for your valuable insights on today's topic. We will now take questions from the participants. The first question is, what is the difference between citizenship by operation of law and citizenship obtained by registration? Since this ties in directly to the discussion Ms. Kirtika has presented, I will pass this to you, Ms. Kirtika.
Okay, so in terms of citizenship by operation of law, as I've discussed earlier, it's automatic and it arises from the child's birth. So the second the child is born, your birth certificate is issued, and then it automatically says work on citizen. Whereas citizenship by registration is not automatic and is subject to the discretion of both the National Registration Department as well as the Ministry of Home Affairs. I've briefly spoken about the differences, the more detailed differences in the processes, and as well as the differences in both applications of citizenship. But the main difference is in relation to the birth certificate. For the citizenship by operation of law, the birth certificate will say that you are warga negara or a citizen, whereas with Article 15A of the citizenship by way of registration, that's not the case. What you do get is a certificate of citizenship.
Thank you. Now let's take our next question. The second question is, how is it that the Court of Appeal granted citizenship in WKH but not in TSY? Ms. Alyssa, could you kindly offer your perspective on this for us?
Yeah, so basically, the cases were different in terms of their facts. So in TSY, the appellant's parents' identity were not known at all. Whereas in WKH, it was suspected that his mother was Indonesian. So that's why he was able to get a letter from the Indonesian embassy basically confirming that he did not have Indonesian citizenship. And he also had a Sarawakian father. So the cases in itself were factually different. And even though while citizenship cases are determined based on existing case law and the court's interpretation, a huge determining factor is also the facts of each case. So that also determines the outcome of these cases and how the courts interpret the law as well.
All right, thank you. And there is a third question. Third question is, can I still go to court even if my 15A application was rejected or delayed for years? Ms. Alyssa, would you also like to address this question?
Yeah, okay. So basically the answer is yes. The decision of the 15A application would not be affected by any court applications for citizenship. And personally, for us, we usually also encourage our clients to do both concurrently at the same time.
All right. Thank you, Ms. Kirtika and Alyssa. First, please join us again for our upcoming talk titled Out of Time, Limitation Issues in Debt Recovery Actions, which will take place on the 11th of February 2026, led by our lawyers, Mr. Liz and Mr. Amir. Secondly, please fill our feedback form and tell us what you thought about our talk. The link to the form will be posted in the chat. Thirdly, do follow and like our social media accounts. And fourthly, if you would like to speak with our lawyers, we offer a complimentary consultation of up to 30 minutes over the phone or over video conference call. Please fill in the form on our website. The link will also be posted in the chat box. Thank you to our guests and thank you for joining us. We hope that you found today's sessions informative and useful. Thank you, everyone, and see you at our next talk.